Should a patent be made litigation grade? Coming up here, we'll be talking about several key topics. First, we'll explore what is litigation grade patents and why it's important, and then we'll discuss things like the criteria that make these things litigation grade. We'll talk about reasons for and against having litigation grade patents. We'll talk about ways to strengthen your patent to get them to litigation grade, and we'll also talk about how, even through litigation, patent litigation, we'll learn about how to strengthen litigation grade patent. And finally, we'll take a look at the future of litigation grade patents and even how AI is going to change that scene. So stay tuned. This is John Cronin from Invent Anything.
Inventions keep the world spinning. From fire and the wheel to today's high tech, inventions power change. Turn your inventions into reality. Learn how to get your ideas to market. This is Invent Anything with John Cronin.
So today we'll cover 6 different topics. The first topic is what is a litigation grade patent and why is it important? The second topic we'll discuss is reasons for a litigation grade patent. And in topic number 3, we'll talk about reasons against having a litigation grade patent. In topic number 4, we'll talk about ways to strengthen a litigation grade patent if you're going to go for it. And in topic number 5, we're going to talk about patent litigation that actually teaches us the things that go wrong that we can fix when we're writing up litigation grade patents. And then we'll talk about the future of litigation grade patents. It's interesting to me that these 6 topics, when they come together, and if I sit back and think about the audience, that certainly one audience would be those not familiar with what litigation grade patents are. If that's true, this podcast is for you. I meet a lot of folks when I'm working with clients every week for the last 25 years, where this topic comes up a lot, and they don't even know what that means. It's a common term used by lawyers, but I don't think we've really delved into what that actually means. Another audience might be for those who are getting patents. You might consider spending extra time to make your patents litigation grade. A third audience will be really for boards or investors, where they're considering if they're going to get into litigation to make sure that their patents are litigation grade. Also, for CEOs thinking about an IP portfolio, this specific topic is really important because designing patents for licensing or for sale or to protect your product or to make them litigation grade, there's different considerations. Another audience might be for those that, when they've heard this phrase litigation grade patent, what does it mean? And so I designed this podcast initially for that audience, but then recognize that there are other audiences. And finally, for those that want to consider getting into patent litigation, this is definitely for you. So coming up, what we'll see is ways to explore what is a litigation grade patent, why it's important. We'll discuss patents that are precisely written on physical products. We'll talk about how claims have to be a one-to-one match so that a jury will understand it. We'll delve into the significance of well-known prior art, what elements of a patent spec might have to be for litigation grade. And then we'll talk about, additionally, the highlights and reasons for having a litigation grade patent, the advantages and why it can help you in a lot of different ways, like leveraging against copycats. So stay tuned for an in-depth discussion on these critical aspects of litigation grade patents. So let's get right into it. Topic number 1, what is a litigation grade patent and why is it important? First of all, a litigation grade patent are really written so that they will have strength in a patent litigation. So that means if you have a physical product or contemplating something close to a physical product, you write a patent by trying to have a one-to-one match between what's in the product and what's in the claim. Now, we could do multiple sessions just on this one element of topic number 1, but it's important to recognize that the patent claims, if there are 7 things in your device, that the patent claim should have 7 things as elements in the first claim. Of course, you could have a broader claim that has less elements, but it's always better for a litigation grade patent to basically have something that maps precisely, because what would happen during a litigation is you'll show your product and you show the patent claims. It would be great to have a column, 2 columns, which matches these 2 things precisely. The next thing about what is a litigation grade patent is that the claims are understandable by a jury. I remember at IBM, when I was running the patent factory there, learning about was earmarked as one of the most important patents IBM ever had, which was the cursor of a computer. And the claim was written, a cursor, the shape of a cursor of a computer change its shape based upon the function the computer was in. As you recall, in the 1970s and 80s, the little line that blinked on the green screen that went to a block for insert mode, that was a patent invention. You can understand that a jury could certainly understand that, the shape of a cursor, line versus block, based upon the function the computer was in, which was insert mode. And so we want to make sure for litigation grade patents that the claims are understandable by a jury. Another thing for litigation grade patents is that we want to make sure that when we write this patent, we really understand the prior art, because you can get a lot through the patent office where there's a lot more in the prior art that maybe the examiner didn't find. For instance, the examiner doesn't look outside the patent literature generally. So there's probably a lot of art out there, in terms of websites and product pictures and things like that. For getting patents, you tend to not go overboard on, really understanding the prior art. But I guarantee you, for litigation grade patent, the defense is going to be all over finding the prior art. So if you want this to be litigation grade, you'll spend almost as much money doing the prior art search as you will for the patent. Another thing about what a litigation grade patent is that the claims are really reverse engineerable. Let's go back to that cursor patent at IBM. I could open up any computer and see that the line was blinking, and when I hit insert mode, it would turn to a block. So it was very easy to reverse engineer. So many patents are written that are not easily reverse engineered. Supposing a process that has 7 steps, where when you look at the final product, you can't see steps 6 and 7. So keep in mind that we want to be able to make sure it's easily reverse engineerable. So I would say a lot of inventions, will make it difficult to reverse engineer. And so when you're thinking about a litigation grade patent, you say to yourself, well, if I can't even prove that someone's using it, it's not very good to take into court, right? Another thing about what makes a litigation grade patent is that each element or step in the claims are incredibly well defined in the patent spec. If you just try this exercise on any patent you got, look at the claim and underline all the different elements and do a control find for your Microsoft Word to see where those elements are in the specification, you will find, surprisingly, that a lot of elements in the claim are not defined in the spec. This is not good, because certainly the defense is going to take every one of these elements and point to the specification and use your definitions for that. And if you don't have a good definition for each element of the claim, what's going to happen is it'll open it up to the debate of what that element meant at the time the patent was filed. So for instance, if it's a flip phone invention and you have elements of the claim and you talk about flip phones, then smartphones that are not flip phones mean that function key might not be on a flip phone. It could be on a user interface, but not as a function key. So really understand what your specification related to the claim elements are. Another key thing about what makes a litigation grade patents is that you should make sure that the patent claims aren't easily invented around. My consulting firm, IP Capital, we have an invent around process of 18 steps, a checklist to invent around patents. We do invent around patents quite a bit. If the patent is easy to invent around, it's not going to be litigation grade, because that means if you bring it towards litigation and try to sue somebody for infringement, if they can easily invent around it, they'll invent around it and then say that even though they may be infringing, there's no going forward damages because they don't need your claim anymore. Another thing about what makes a litigation grade patent is to make sure there's direct infringement versus contributory infringement. That means the company that does all the elements or steps in the claim is the same company, where 2 or 3 companies couldn't be doing parts of it. Because if you have to bring contributory infringement in, it's going to be more difficult to win in a litigation. So write every claim that you have for litigation grade to be dedicated towards direct infringement. And by the way, there's a trick to the trade on how to do that. I won't go through this here, but any patent counsel would know that. Another thing we found, and this is kind of interesting, and probably not a lot of counsel might know this, but they know it intellectually, but they wouldn't know it from this perspective. And that is, make sure the grammar of the claim is not confusing. It's confusing if there's a lot of commas and there's a lot of ands and there's a lot of elements and it's a very long claim. So it's more precise in that IBM cursor patent, the cursor of a computer that changed its shape based upon the function the computer was in, end of statement in a sentence. That's very easy for a jury to understand, and it's not confusing. There's only 3 or 4 elements there and how they're connected. So if you read a claim and you're not quite sure whether it means something or something else, then it's not litigation grade. Another thing is that we want to make sure that litigation grade patents have claims that are specific to match the product. Remember that one-to-one matching. But on the other hand, we don't want to make it overly broad, because if it's overly broad, I mean, you do want to overly broad patents for licensing, where it's not in a court of law, where the licensee would say that their desire for that claim is broad or fits in your broad description. In litigation, the broader you make it, the harder it is it's going to get the jury to accept that you own all that territory. In other words, the specifics of what a person is doing in their product reads on some generality in your claim. So you want to try to get them matched as close as possible. And finally, another thing of what makes a litigation grade patent is inventorship and ownership is correct. I can't tell you how many times we worked on cases where there's multiple inventors and one inventor is no longer with the company, and they bring the inventor in on the defense side, and it's not a friendly discussion because the person was fired or laid off or something, and therefore won't cooperate. And that makes it very difficult to litigate. So you want to make sure the inventorship and ownership and all that's correct, but also that it's correct in the sense that these people will support you. Now, here are 10 things I mentioned. There are others. So these are the top 10. We don't have time to go through all the things that we would do. But if you're seeking a litigation grade patent, this is a great start. If I go to topic number 2, reasons for litigation grade patent. If you have a good litigation grade patent, the probability for success at litigation is higher, of course. Another reason for having a litigation grade patent is if it's really strong and very specific, then copycats are very likely not to copy you because they can see very clearly your patent reads on a product they might want to build. Another thing about litigation grade patents is if you're trying to license or sell your patents and the licensee or the buyer looks at the patent recognizing, oh my goodness, I'm infringing this, it's much easier to sell or license that patent given that. So it's a very good reason for having a litigation grade patent. Now, I said earlier that some patents are written for licensing, and some might just be used for litigation or both. But I would say the default is to try to get them to be litigation grade, at least to that level of making sure it's great for litigation. And if it's good for licensing because there's broad claims as well, that's also good. So they're kind of in parallel with each other, but in considering a litigation grade patent, consider that first versus its licensing aspects. Another reason for litigation grade patents is they allow a company that's going to have a litigation strategy to be very aligned. I've made a lot of companies that say their patents are for litigation, but they never took the time to go through the patents, making sure they were litigation grade. In other words, my strategy could be that I'm going to win against this particular, army or competitor, but have no specifics or making sure you don't have the right weapons or the right competition capability. So make sure if litigation is going to be part of your strategy, that you go back to topic number 1 and make sure it's litigation grade. Another thing about, reasons for having a litigation grade patent is it's really easy in one sense to have it to cover your own product. On the other side of this, if you're trying to project where your products are going to be, and it becomes difficult to make a litigation grade patent because there's a lot of variation of what it could be. The other thing we found is that when companies have really good litigation grade patents on the product they have, eventually they start changing the product, and the product changes outside the claim scope. So therefore, when someone copies that new product instantiation, they're not violating the patent. So there's multiple things that can happen here, but to make sure that your own product is covered by your own litigation grade patent. Another reason for litigation grade patents is that you should see an enhancement of margins in the product. There have been many studies that have shown that if a product is patent protected versus one that isn't, you should see 30, 40, 50% higher margins. So a good reason for having litigation grade patents is it should increase your product's margins. Another reason for having litigation grade patents is it's easier for litigation financing. Just recently, last week, we closed a deal from one of the patents we wrote that we got 100% financing for the litigation. That doesn't happen a lot. The only way that happens is that the patents are really well designed for litigation grade. If you have patents that are just patents written and you hope to get litigation financing, you will find that the people that want to do this on contingency are going to attack your patent in a lot of ways, particularly in topic number one. They'll go right through those and other things as well. So if you want to get litigation financing, spend the time and the effort and the money to make it litigation grade. Another thing, and a reason I have litigation grade patents, is it's easier to find a broker. Over the years, I started and sold a licensing company. As a licensing broker, we had 10 or 15 licensing executives. And for 4 or 5 years, what we're doing is finding patents that we could license. And what we found is that our firm would more than likely take a deal if the patents were really litigation grade. In other words, you had evidence of use and all the rest. So if you're trying to find a broker down the road to license or sell patents, and that's part of your strategy, please make sure they're litigation grade. Another thing is that if you have litigation grade patents, one obvious thing that happens in an M&A is the acquirer is going to look at your patents, and if they really feel that they could lose in a litigation, the value of that M&A is going to go up. And finally, one other reason to have litigation grade patents is if you're going to be considering litigation, that's going to cost a lot of money and a lot of time. So you should consider putting the extra effort in to make it litigation grade. You can't make it litigation grade 3 or 4 years after it's issued and you're deciding to go towards litigation. So please think about that. So coming up, what we're going to do is discuss reasons against litigation grade patents and then also ways to strengthen it. We'll explore how these things can be expensive to craft, may not significantly impact your patent valuation. We'll discuss how future litigations and the risks of disclosures requirements might change things. We'll also talk about how owning such patents actually can invite litigation. Additionally, we'll talk about the strategies that we can use to strengthen litigation-grade patents. Things like clean title and ownership, ensuring inventor alignment, creating willful infringement scenarios, doing things like evidence of use. So stay tuned for a discussion on how we can strengthen litigation-grade patents, as well as reasons against litigation-grade patents and how we balance those. So let's move on to topic number 3, reasons against litigation-grade patents. Now, a little bit of warning here. I would bet you that a lot of people, especially attorneys, might say, this is absolute nonsense, that every patent should be made litigation grade. And I get that. If you're coming from the fact that the only way to make money from patents is to enforce them, there's a podcast that we've written and done about 6 ways of making money for patents: buying them or licensing them, using them to leverage M&A, using them to raise money. In all these other ways of getting value out of patents, litigation grade is not needed, okay? Litigation grade patents are needed as a class of patents if you're going to take it to litigation, because there's a lot of work you could do to make it really litigation grade that you wouldn't do if you're trying to build a portfolio. I can guarantee you, when I ran the IBM patent factory, we were generating 3,500 patents a year. There was no time to make those patents litigation grade. Of course, there were some that were selective to really make sure they work well, because we knew the key products were going to be issued on some of these patents. But all the rest, not litigation grade. So let's talk about reasons against litigation grade patents. First is they're more expensive and timely to craft, no doubt. We would spend probably 2-3 times longer on litigation grade patents. We mentioned the prior art search could cost almost as much as the patent application writing. So one reason against is it's very expensive. It takes a lot of time. Another reason is that if you're trying to think that it's going to impact your valuation, we do in our consulting firm 2 or 3 patent valuations a month. And we risk adjust the patents in the valuation. But nowhere in that patent valuation have we ever found that litigation grade was assessed and where the litigation grade made it valuable, because most of the ways that we value patents is on a licensing model, which doesn't require patent litigation. So if you're thinking about spending the time and money to do litigation grade, but you're thinking about doing it to improve the value of your patents, I wouldn't go there, because as an expert in patent valuation, it doesn't move that needle. Another reason against patent litigation grade patents is to litigate against someone else. You have to assume that they're going to have a product that looks just like the product that's in your claims. Now, supposing you want to do this, you want to write patents at a litigation grade on somebody else's products where you don't have that same product. So that means you're going to have to take a product that exists or close, project where it's actually going to head, and write claims on that future. That's very difficult and very unlikely generally, unless you have a crystal ball. You have a time machine where you can go forward in time and see exactly what that product looks like. So one reason against litigation-grade patents is to be thinking, I'm going to write litigation-grade patents, not for what I have, but for what somebody else could be doing. Very difficult. I spent my life trying to figure out how to do this. I still haven't figured it out. A fourth reason for litigation-grade patents against it is the disclosure requirements. See, when you file a patent, you have to have your best mode in it. And you may divulge trade secrets and all the rest to do that in order to have a good litigation-grade patent. You see, in a litigation-grade patent, you want to divulge all the things necessary that you can then claim and teach. Whereas if it's going to be used for licensing or for enhancing an M&A or for selling, you might not go through that effort. So one reason against litigation-grade patents, and I've seen this time and time again, is they don't want to disclose some details of their product or method or whatever, because they would rather take the risk of having that trade secret versus teaching someone directly and having to go to court to stop others from making, using, and selling. Another reason against litigation-grade patents is owning a litigation-grade patent can sometimes invite litigation. I have at times had someone call me that they needed some help because one of their competitors is suing them. I get behind the story and find out that one of their patents that they wrote was very litigation grade, and that competitor was worried that they were going to be sued. So they decided to sue first so that they could, convene in the jurisdiction that they want before the counterclaims would come from my client. So sometimes litigation-grade patents can actually, start the litigations by someone else suing you. I mean, just sort of think about it. If there are two communities, two communities next to each other, and one starts to build up armaments, the other community next to it might wonder why they're building up armaments. they might build up armaments. Sound familiar? Another reason against litigation-grade patents is it creates materiality issues at the board. If you have and with executives, if you really have great litigation-grade patents and everyone on the board knows that, the next question is, why aren't we suing people? And I have stepped into a number of clients and had to talk to boards and so on, that when they focus on litigation-grade patents, and I've been a board member at public and private, chaired public and private companies, and this is a matter of materiality, okay? That if you have really strong litigation-grade patents, the question is going to be asked of the average shareholder, why aren't we using litigation? And that's a very complicated thing to resolve. Another reason against litigation-grade patents is you're going to start thinking about your litigation capability as a mechanism to win in the market. And I've seen clients that have such a good, strong litigation-grade patent group that they tend to stop developing their product robustly, stop driving the cost down, stop adding functional features, because they think they can win in the market with a litigation-grade patent. So there's dangers in this as well. Although litigation-grade patents, as mentioned, it's a whole world on how to do it right. And if it really works well, it can create a lot of leverage. But there's a lot of kind of psychological baggage that comes along with it. Another reason against litigation-grade patents is it creates complications in the market. Like if you've got litigation-grade patents, they may read against your customer, and you're trying to get your product sold so the customer will buy it. The customer may be thinking, if I buy from you, I certainly won't get sued from you, but you have patents that could litigate against me if I buy from somebody else. So it sets off this tone that I don't really feel like your customer, because at any moment we decide that your product's not working for us and we buy from somebody else, you're going to sue us. It's also true of partners. So having litigation-grade patents sometimes adds market complication. Another reason against litigation-grade patents is that someone in your company may think you are so strong and so good with litigation-grade patents that all of a sudden they could be worried that you could get a declaratory judgment. In other words, some company starts to think through something that marketing said or something that was in one of your product brochures that, how you were better than a competitor, and then you list your patents, that they could be worried that maybe, just maybe, you're going to sue them. And so what they go is after a declaratory judgment against you. We've seen this as the number one reason when we do licensing for our clients to not divulge that our patent's litigation grade. The last thing you want to do when you try to discuss licensing is to talk about that, your patents are very strong from a litigation standpoint, which then means, oh, that means you could sue us, which then means maybe I'm going to do a declaratory judgment to stop you from suing me first. So think about that complication. And finally, another reason against litigation-grade patents is that you could force your potential copycat or competitor to take that patent that just is really written well, maybe even against them, to invent around you. And so by having a litigation-grade patent, you could force the competitor to do a very good invent around to not fall into your claim scope. Sounds complicated, right? There's reasons for, reasons against, and it seems like they're all counter to each other. I just want to create this balance sheet for you about reasons for and reasons against, because in any one of these areas, it could be just enough to say that's the reason why we're not going to create litigation-grade patents, or the other way around, that's the reason why we really should create litigation-grade patents. It's good to know there's a dozen things on each side to consider. So let's go to topic number 4, ways to strengthen litigation-grade patents. We mentioned some of the problems. So obviously one of the problems that we could strengthen is clean title and ownership. Look, I've mentioned the fact that, having title to your inventions is important in many other podcasts we've done. But when you file the patent and you have, the assignment, make sure the assignment's correctly written to your company. But it's more than clean title. It's ownership in multiple ways. That inventor that created that patent, if you think you're really going to use that for litigation down the road, it really makes sense to just have a very comfortable relationship with that inventor, because that inventor is very likely to be pulled in to the litigation, and the defense is going to try to get that inventor to turn against you about what this claim actually meant and what the contributions were, etc. So if you for some reason can't afford to keep that person on, but they're one of the inventors, there's all sorts of tricks of the trade to make sure they're happy with your firm. Another way to strengthen the litigation-grade patent is to make sure that not only ownership and title is right, but try to get away with having as few inventors as possible. In many companies we've worked with where we brainstorm and we have lots of people contribute, we have lots of inventors. And we really try hard to make sure that the inventorship is absolutely correct. If you have multiple inventors, they all made contributions to the claims. You see, one of the things that a defense will do when they see a patent that has 4, 5, 6, 7, 8 inventors is to attack directly this idea of incorrect inventorship. Another thing to strengthen a litigation-grade patent is to try to create willful scenarios. And what do I mean by that? Well, first of all, if you win a litigation, the judge is at the end of the litigation is going to rule whether or not the infringement was willful. And the judge can take any damages and multiply them up from 1x to 3x and anywhere in the middle if he felt that it was willful infringement. Now, how do you create willful infringement? Well, one thing to do is to at least try to get a license from the company. Right now, we're dealing with the company that we've helped them generate some patents. We helped them try to generate licenses to several companies. Now those companies are violating the patents. And now we can easily say that the company actually knew of our patent because we have the paperwork to show that we sent the patent to them. So now a case is being made, right, for willful. Of course, you need a lot more than that to prove willful. But setting up willful infringement scenarios will help the value of your litigation. And sometimes companies on the defense side may settle more quickly if they sense that the damages could be 2, 3x. Another thing to do to strengthen your litigation-grade patents is to patent around your own patent. So that if someone does try to invent around your patent, they land on one of your invent arounds. It's a key thing, and as I mentioned, we have invent around techniques we've been using for years, an 18-point checklist, if you will. So it's really important if you're going to have a willful infringement, if you're going to have a patent litigation grade patent, that you spend the time not only to make sure that that patent's right, but also to add the invent arounds. Another thing to do to strengthen litigation grade patents is to leverage things like offshore issues, like the ITC, the International Trade Commission, whereby if you sue, say, in the United States, that could take 3 to 5 years to go through the docket and have all sorts of other issues in collecting funds. However, if your patent is in the US and your competitor is shipping through into the US, sometimes the ITC can step in and basically rule that they can't ship product in, which is a very big deal if that's a big part of the competitor's market. So if there's any way to leverage offshore issues for your litigation grade patent, please think about that. Another thing is, we mentioned this a couple times, but if you're going to have ways to strengthen your litigation grade patent, it's important that you do evidence of use. In our episode 15, which is evidence of use detecting patent infringement, you should take a look at that podcast. You can go in detail on that. And that evidence of use should be done routinely. It should be updated every 6 months or so. Because what you want to do is to convince yourself there's evidence of use of your patent for litigation, but you want to make sure that doesn't change. So if you got a litigation grade patent, it makes sense to put the money in to actually comb the industry to see if anybody's violating it. Because they come together. As I mentioned before, litigation grade patents are more expensive and more time consuming. But if you're going to get a litigation grade patent, the next step is to do constant evidence of use. Another way to strengthen your litigation grade patent is through regular updates. Take a look at the patents and products in the market, and continually draft new continuations if you can, more specifically reading on others' competitors' products. Another way is to improve your litigation grade patent is maintain confidentiality before filing. This is vital because if you submit a patent to the patent office, even if it's great litigation grade, and it can be shown you divulge this to public, then that patent's going to fall. So, because, it was your own prior art. Your patent counsel can surely take you through the pluses and minuses of how to do this right. But so many times we've seen that the company spent the time and effort on a litigation grade patent, and then recognizing that they were showing their prototype that was their patent claim 2 years before they filed their patent. So that would make it likely to be invalidated. So make sure that the confidentiality is maintained on your litigation grade patent. Another thing is to strengthen litigation grade patent is focus on enforcement mechanisms. What that means is if you have a litigation grade patent and you want to strengthen it, make sure you're identifying the potential infringers and monitor them constantly, and always get prepped for litigation. Now, I'm not saying you get prepped for litigation as if you're headed right for litigation, but there are things that you can do to ensure that you're always focused on litigation. So another way to strengthen litigation grade patents is focus on the enforcement mechanisms, along with making sure the patent is written correctly for litigation. And this is like having clear strategies for enforcement means that you're spending time identifying the infringers, spending time making sure the inventorship, is correct and in your boat, so to speak, and even doing things to prepare for litigation, making sure all the documents are in place, or making sure that you've picked the right firm, for instance, to help you in the litigation. And finally, another way to strengthen litigation grade patents is to proactively invalidation searches. So the first thing the defense is going to do is try to invalidate your patent. So if you can constantly keep a lookout on how your patent could be invalidated, it will be stronger by the time you get to litigation. So the first thing the defense will do is try to invalidate your patent. A lot of times firms will try to invalidate their own patents through their own process. And if it isn't invalidated, then it's more litigation grade. So coming up in our next section, we'll deal with how patent litigation teaches us to improve litigation grade patents, and also talk about the future of litigation grade patents. We'll get into the importance of expert testimony, early involvement of experienced legal teams, use of multiple claim types, and things like that. We'll also cover towards the future of patents written for litigation grade, is how AI is going to help that whole scene. So stay tuned. But let's get into topic number 5, patent litigation that teaches us how to improve our litigation grade patents. So the last thing you really want to do is be involved in patent litigation if you can help it, but if you have to, you'll learn a lot, and then you'll learn the things that you wish you had done when writing up your patent. So let's go through some of those and have a little bit of fun with this. One thing is, obviously, when you're in litigation, they require expert testimony, where they're getting experts to look at patents and talk about things like what the value of it is, whether they're operable or not, things like that. So it would behoove you to maybe get some experts after you've got your patent, litigation grade patent written, to bring in some experts, to spend a day or two playing devil's advocate, to basically talk about why this thing is not valuable, what's wrong with it, etc. Another thing you learn when you're going through patent litigation is legal teams have to be involved in the litigation, obviously. And what you learn is that when you're drafting the patents, litigators, when they're looking at the patents to, be the plaintiff, are always wishing that the claims were written different, more specific towards litigation. So it would behoove you, if you want to do patent grade litigation, that you spend the time, once you get the patent written and done a good job there, that you basically have maybe a litigator look at the patent claims to suggest ways to strengthen it. Another thing we could do to help, based upon learning from litigation, is that one of the great things to do when you're drafting claims is have multiple claim types, because you may find that the apparatus claim is stronger than the method claim of using the apparatus or operating the apparatus or the system. So having really good litigation grade patents would mean that you have various claim types to rely on, because sometimes the method of operation is much stronger than the actual apparatus or system, and sometimes vice versa. So having them both to hedge your bet makes sense. Another thing to do that patent litigation teaches us is study the judge's decisions. We recently had a client that was determining whether or not they should go forward with litigation. And it turned out that the attorney quite rightly said, let's look at some of the case law and let's look at some of the judges that would probably take this case in your venue and let's see their rulings. Well, that's exactly what we did. And because of that, we recognized our claims were not drafted towards the way that the judges would most likely rule. So that changed the scenario. So we then had to stop and take some continuations and rewrite them to align it with what we thought the judges would actually decide on. Another thing that patent litigation might teach us to make our patent grade litigation patents better is anticipating counter arguments. I call this, and I mentioned this before, the devil's advocate approach. Pretend after you've written the patent that you're the defense and you're trying to knock down the patent. That one process, by spending 2 or 3 hours on that, will give you all sorts of input to improve your patent. Another thing to do that litigation teaches us is learn from competitors' patents. Certainly you're writing patents a certain way and so are your competitors, but you may find that competitors are actually adding some language in their claims that appear to be more indisputable than the way you're doing it. So I can't stress enough that when you're writing your litigation grade patents, read enough of your competitors' patents. Particularly if you're a small company, you think you're going to litigate against a large company. You may find you learn a lot about the patent claim strategies from large companies that you can embed inside of your own claim types for your small company. Another thing that we recognize that happens quite a bit, and this is the reason why I've been on the witness stand a bunch of times over my life in patent litigation, is to document the inventing process. And what we mean by this is that through litigation, many times the inventor are brought up, and the defense is always trying to tear down how the inventor invented, why he thinks he's the inventor. And things come up like, was there an inventor notebook? Did you issue a report? Are there emails between you and your team or you and the management about what exactly this invention was? So if you have a good litigation grade patent, you should have behind it all the paperwork and all the documentation that showed how this was really developed by the inventor. Another thing that we learned from litigation is that there's nothing like having a little mock litigation session. In other words, even if it takes 2 or 3 hours to present the claim and the reasons why that product is infringing, to have a group around you sort of take it apart. This is another level of the devil's advocate process. Another thing we learned from litigation is thinking about preparing for post-grant proceedings. I mentioned this IPR review, it says inter partes review. But basically what it means is when you try to litigate with one of your patents against someone, they're going to try to take it and invalidate it. So you could literally learn from litigation that this is going to happen almost all the time now. So you might as well go through that IPR process, at least internally yourself, to figure out, where you may not have strength or where you do have strength. And from that, determine whether you really want to go through litigation. But even from that, in turn, how to feed back and write a better patent litigation grade patent. And finally, we mentioned this devil's advocate process, and we also mentioned doing an exhaustive prior art search. But one thing we learned from litigation that I can't stress enough is that so much money is going to be spent by the defense on prior art searching that you should look and do a devil's advocate approach on how well you're doing prior art. In other words, who's doing the prior art search? Is it someone that's just an attorney that is doing this for a couple hours? Or are you having multiple groups doing this? Are you using crowd searching? At one point, I bought a company called Article 1 Partners, which had 150,000 folks on their mailing list that you could send patent claims out to, finding someone from the crowd who could find prior art against that claim. So there's a lot of business models today that go out there to try to knock out patents. And if you want a litigation grade patent, you should try to do that. So whatever litigation grade patent is going to cost, it's going to be multiple times what a regular patent is going to be. Well, let's jump to the final topic, topic number 6, the future of litigation grade patents. Now, one thing we're starting to recognize, and this is happening quite a bit, is we're using artificial intelligence, Bard or Claude or ChatGPT or whatever, to use these large language model tools to help us with patent applications. What's really great about these tools is they don't go to sleep and they're not tired. So you can really write a really good draft and then go through that draft with ChatGPT or large language models as your partner to embellish examples, to help you find more specificity around your claim elements, etc. So all the things you do to make your patent more litigation grade, you could bring in your buddy called large language models. Another thing you could do is you can use automatic tools now that are AI-based that do rapid prior art searches for you, analyzing against vast databases. So you could search for your patent against everything from, the patent literature to, engineering databases or, all sorts of scientific databases, etc. Maybe even search in different languages, etc. Because all this will help you with the prior art search. Another thing about the future here is, and this is going to be brought up, as you get embarked on using AI to help you write your patents, you're going to find out that the European Patent Office has now come out with new specifics of what they'd like to see when a patent is written up using AI. They give formulas as to the things they'd like to see in the patent now to actually prove that if your patent is based upon AI, that you do certain things to make it shown that it works through AI. On the other side, the U.S. patent system is also saying similar things, but ask you to keep track of your contributions through the process of what is and what isn't AI assisted. Because I believe what's going to happen in the future is the defense is going to start using the fact that some patents were written mostly by an AI agent, and therefore, the AI agent, the ChatGPTs are not inventors. And so I think being very careful about this in terms of making sure you actually are inventing it as much as possible. You're using these large language model tools to assist at some level, but also following the guidelines of the patent offices. Another thing that is probably likely in our future is using advanced AI for infringement detection. So a number of years ago, we wrote a web crawler for evidence of use to take patent claims and go see if we could go find evidence of use. That's going to get better and better and better. In the very near future, and it's on our whiteboard of how to do this, is you can put in a patent claim and it will go find the infringement automatically. That's the near future. And so we need to be ready for that because it's very likely that somebody's going to put our product may come up in these AI searches for evidence of use. Another thing in the future is we're going to use AI in patent prosecution. That is to say, we can use AI to analyze office actions, AI to analyze patent attorneys' responses and patent attorneys' strategy, use AI to go after all sorts of things. Another thing that will happen is we'll use AI to go into the case law to find out how the judges are ruling. We'll also use in the future sort of predictive analytics for litigation outcomes. There are already tools to do this where by reading what the judge's rulings have been on 10 cases, the AI predictive analytics can tell us, what the likelihood of our case going through. And as I mentioned, it's good to know what the judges are ruling. So now we can use AI to help review the judicial decisions to give us more input on what our strategy should be for litigation. There's also AI tools out there today to help us with claim construction. So AI can be a great devil's advocate tool, for instance. And then finally, in looking at the future, there's still going to be these ethical considerations. Is AI going to be an inventor? Right now, the Dabas case, Stephen Taylor, one of our friends, is tried to get a couple of patents through the patent office where the claim was that the AI was the inventor. Well, I think in South Africa it has been allowed, but in the US and the UK and others, it hasn't been. This is the beginning of a fork of a road that has been taken that won't stop. So we have to keep track of also thinking about how AI could be the inventor and always making sure within the bounds of the law and the ethics, so that if we do want to get a patent litigation grade patent, that we have that covered off in our thinking. So let's wrap up. In topic number 1, we talked about what is a litigation grade patent and why it's important. We discussed things like this one-to-one match between the physical product and the claim set. We talked about how it should be understandable by a jury. We talked about how it should be easy to reverse engineer. We talked about how there should be multiple examples in the specifications. We also talked about having that specification being incredibly well written, the claim elements to the specification definitions. We talked about using event around strategies. We talked about watching the grammar of the claims and making sure they're not too confusing. And we also talked about keeping track of inventorship and all those things that have to do with the documentation of the inventor. We moved on to topic number 2, reasons for litigation grade patents. First of all, litigation grade patents are really crucial for a lot of reasons, like increasing the probability of success of litigation, making sure you have strong leverage for licensing or selling. Even the threat of a lawsuit is very clear to help you in winning, in negotiating deals. We talked about having a robust litigation strategy and then marrying that to the litigation grade patent. We talked about things like your product margins being enhanced with this. We talked about ways that ensures that patents make it easier to secure litigation financing if they're well written. We talked about it's easier to get brokers. We also talked about how these litigation grade patents are really good for, in an M&A valuation. So ultimately, there's so many great reasons for having good litigation grade patents, which leads to topic number 3. We actually talked about what's the reason against having litigation grade patents. First is they're expensive, and second is they're time consuming. The next is that the disclosure requirement may mean you have to divulge too much. Owning such a patent could actually bring out litigation, we talked about. Relying on litigation grade patents also means that your executive level, the boards and investors, now have a different materiality to think about. We also talked about how this patent might shift the focus away from product excellence. We need to be worried about that. And then we talked about the complication in the market, what it does to your competitors or partners to know that you have a litigation grade patent. It's a lot to consider. And finally, having good litigation grade patents, we talked about the internal issues, that all of a sudden you could push litigants to invent around you in the market. So there's reasons for and there's reasons against. In the 4th topic, we talked about ways to strengthen patent litigation grade patents. We talked about ways that we could do this by, for instance, ensuring clean title, create willful infringement scenarios, make sure that you're engaging in industry education of what your patent claims are to get that willful infringement sort of in play. We talked about how you could cover alternate routes, inventing around your own patent, pretty crucial. We talked about maybe taking advantage of the ITC and offshore issues. We talked about regular continuations, always crafting those patent claims towards future products. We also talked about how imperative it is to maintain confidentiality, to not divulge this, because that might come up in the defense that someone might show a slide from a presentation that you did a year and a half before you filed your patent that claims your invention. And we also talked about, doing proactively invalidity searches to make sure that you know where you're at. And that's a way to strengthen your litigation grade patent, because that will come up. In topic number 5, we took the exact route of asking the question, okay, what can we learn from litigation that can help us strengthen our patents specifically? So we talked about expert testimony. Maybe you want to hire some experts to look at your patent before you file it. Maybe you get experienced patent attorneys that are both litigators that look at it from a litigation standpoint and give you a report on that. More cost, but they certainly will get better. We talked about having multiple claim types. Sometimes an apparatus claim works better than the method claim or vice versa. So having multiple claim types help. We also talked about having counter arguments and doing this devil's advocate approach, which I can't say enough about. Devil's advocate at the claim level, devil's advocate at the specification level. We also talked about how you can look at competitors' patents and learn how they're written, because maybe you can include that in your litigation grade patents, so that, because what happens is when you go into litigation, what you learn from litigation is you're reviewing other people's patents and you wish that your patent was written in a particular different way. You also want to maintain detailed records of the documentation, because that always comes up. What was the inventor doing when he filed the disclosure statement? Does he have adequate documentation? Is there inventor notebooks? We talked about mock litigation processes. We even talked about, having sort of a mock or semi-inter partes review yourself. And finally, we talked about that you can't do enough about looking at prior art, and you should have a devil's advocate process to look at how well you actually are looking at the prior art. In topic number 6, we talked about finally the future of patent litigation grade patents. So litigation grade patents are, as we mentioned, something that is very specifically written for litigation. And so what's happening here is that AI is going to play a role. It's going to play a role in helping us draft the claims. It's going to play a role in automating prior art search. It's going to play a role in how the AI can help us, lead to questions about what we should do when we're drafting it. It's going to play a role in the prosecution. It's going to play a role in studying case law. It's going to play a role likely in looking at the case law and determining what the judges may rule. It'll also probably likely play a role in interpreting the claims relative to the specification for litigation. And finally, it's probably going to get to the point where the AI itself might be the thing that helps you create those patent claims, but the future would be that the AI itself may generate the patent or may come close to generate the patent. So we always have to have sort of the thinking that if we're going to use AI to help us, we have to draw the line ethically to make sure AI isn't doing all the work, and that we need to follow the Patent Office's guidelines. And finally, that in the future here, AI is going to help us with everything. So we want to make sure that if AI is going to help us with everything, we leverage it as much as we can, but we make sure ethically, it's not doing all the work. AI is going to be everywhere in patent litigation. This is where there's a lot of money. And so if you can have AI agents to do things, to make things faster, better, cheaper, or higher quality, it will happen. So there's a lot of things that AI will do in the future of patent litigation. So I guess that wraps it up. I decided to do this podcast because a lot of our clients kept asking me, what is a litigation grade patents? So I decided over a couple of weeks to sort of take a look at that, reasons for it, reasons against it, trying to define it, talking about how it can be leveraged, talking about, the things that we can learn from litigation to make it even stronger, and then finally considering what the future holds where AI comes into play. So if you like what you heard, please subscribe. Come join us at our Invent Anything blog, and please take a look at our new series for inventors at work. This is John Cronin, Invent Anything.